Hello, good morning, everyone, for joining us today online talk, which will be starting very shortly. For those who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us today's online talk titled Understanding Medical Negligence Claims, a Patient's Guide to Medical Litigation. My name is Muhammad Akhil Shah bin Asharuddin. I'm an associate with Mah Weng Kwai and Associate, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Mah Weng Kwai and Associate is a mid-sized firm founded in 1985 by Dato' Mah Weng Kwai. Our team today comprises of 36 lawyers and 30 support members. Dato' Mah is today a consultant with the firm following his retirement from the Court of Appeal. The firm continues its tradition today for working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relation team, and a department that focuses on serving the needs of individuals and families. Our practice group indicates some of our focus areas which are supported by talents from both our corporate and dispute resolution team. So today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were broadcast live. However, with the COVID-19 MTO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsels. So before I continue, please be reminded that this talk does not constitute legal advice. In any event, you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be provided after the talk. So for today, we have two speakers, which is Jeremy and Jace. Firstly, Jeremy Balang is a senior associate practicing in areas of medical law, personal injury, debt recovery, and also general litigation. He was admitted to the Malaysian bar in 2018. He specializes in acting for patients and or their family members in medical negligence claims against owners and managers of hospital healthcare practitioners, including doctors and nurses, and their respective professional indemnity providers. Our second speaker is Jason Lim, who is an associate in our medical and personal injury department. He was admitted to the Malaysian bar in 2021. He has a Bachelor of Law degree from Queen's University Belfast. His area of practice includes medical negligence, personal injury, occupiers liability, and general litigation. So for today's talk, we have four main points which will be discussed with our speakers. Firstly, assessing the viability of a claim. Second, filing a medical negligence suit. Thirdly, understanding the pre-trial processes. And lastly, trial and settlement negotiation. And last but not least, we will conclude the session with a Q&A. Without further ado, I'll pass the floor to the speakers.
Thank you, Akil, for the warm introductions. As previously mentioned, I'm the head of my firm's medical department, and we primarily act for patients in claims against hospitals and doctors. I will speak on the things to be done before a suit is filed, whereas my colleague Jason will be speaking about the matters to be attended to after the suit is filed. Now, for some of our participants in this webinar, there may be a question as to what exactly is a medical negligence claim. Such a claim would involve a patient bringing a suit, perhaps their family members as well, for negligent treatment that caused them to suffer harm. Common examples may include delays or failures in diagnosing a particular condition, failure to undertake or carry out a particular surgical procedure with the necessary due care and skill, failure to provide advice and information towards a particular condition or treatment option, etc. There are many different kinds of examples. But I thought to start this webinar by talking about one example in particular, one that was in fact read in the courts and decided last year. It's the case of Lim Yok Ha. Now, I had the privilege of being involved in this case in the trial courts, and it's the most interesting one. So we have at the time, 70-year-old woman who was admitted to Prince Court for dengue, and she was treated, but she was, even from her admission, classified as at high risk of falling, right? And there are certain procedures to be undertaken in this regard. One night, in fact, the night before she was discharged, she was set up on her bed by a nurse, and she fell off the bed afterwards. She landed on her head and suffered an intracerebral bleed. She was in a vegetative state for the entire period of the trial, including right after the accident and even until the decision was delivered in 2024. A number of interesting facts about this particular case. One, the court awarded about 4.2 million in damages, and the matter is presently on appeal. Two, the case actually saw 3 different judges, right, over the course of, I think, 4 years. 5, the issue, the cause of a fall. It was only found at trial that it was a mechanical failure on the cot side of the hospital bed. Now, this was only because in cross-examination by one of the doctors involved, it was let slip that it was a common thing in that particular hospital that the beds were often failing. And it was later learned, in fact, that after the incident, after Lim Yok Ha had fallen on her head, all of the hospital beds in that hospital were replaced, or at least the older versions that were constantly having mechanical failures. But in fact, the High Court in this case had awarded, amongst other things, a record 1 million ringgit in damages for aggravated damages. And in its grounds of judgment, the High Court had made the following findings. When Madam Lim's family had sought explanations from Prince Court, had attempted to blame Madam Lim by falsely claiming that they were not informed of her prior fall, despite documentary evidence proving otherwise. Fun fact, in this case, at least very early on, there were all sorts of defenses thrown. There were suggestions that Lim had tried to climb out of the bed on her own. There were suggestions that the family members had failed to be with her in the wee hours to prevent her from falling. There were allegations that apparently the accident was unavoidable. It was an inevitable accident. In fact, 6 months after the plaintiff in this case filed suit, the hospital actually filed a separate suit for recovery of medical expenses, which was eventually dismissed by the court. So that's one. The High Court, in awarding aggravated damages, also held that the hospital did not come clean but continued to pervert the course of justice. There was deliberate non-disclosure of material evidence by the hospital, including incident reports prepared by the on-duty nurse and the internal nursing review conducted into the fall. And that even after the court mandated the release of these documents, there was a conscious failure to provide the complete documents. There was also suppression by Prince Court of evidence and knowledge of the cause of the fall, which resulted in Madam Lim suing her physician and nurse and which had caused unnecessary stress and attack on their reputations. The Prince Court had also failed to report the fault to the Ministry of Health pursuant to a particular directive by the Ministry of Health, and which would have prompted a statutory inquiry into the fault. It was also common knowledge in that hospital that the cot sides of the beds at Prince Court suffered mechanical failures, and that the outdated beds should have been inspected and replaced promptly. Unfortunately, in this particular case, it took Madam Lim's case for the hospital to replace all the old beds with the new ones. In fact, the High Court judge used the adage of penny wise but pound foolish. The matter is pending appeal, but unfortunately, shortly after the decision, Madam Lim Yoka passed away. To her great credit, she stayed in a vegetative state for so many years, outlasting even the estimates set by the defense rehab expert on how long she would live. But this is just one of many cases that are often seen in the courts. And the amount of work, the amount of detail, the amount of thought that went into this particular case, it's not something that would be evident in any grounds of judgment. So let's talk about the steps about what to do before the filing of any suit, right? The key word here is being before. The first thing you should do is contact a lawyer. Many patients, in my experience, do try to take matters into their own hands for various reasons. And for many reasons, that is often not the best thing to do, right? Speak to a lawyer and get advice on what to do, including the next steps. It is always better to have legal advice for too many reasons to be elaborated on. But the first thing that your lawyer would do would be usually to obtain copies of the relevant medical records. After obtaining the records, then a review of the records will be done, and then your lawyer will engage an expert to look at the case. And finally, assuming that the report is supportive and the client instructs as such, the cause papers will be prepared in respect of the suit. This would entail, for example, the writ and the statement of claim, more of which my colleague will speak about. But before we even talk about bringing a claim, the first thing that ought to be asked is, what is my timeline? Do I have limitation as an issue? There are many different limitation periods, right? And some of them can act concurrent to each other. So if, let's say, I want to bring a claim against a private hospital, I have 6 years from the date of the accrual of the cause of action. But if I want to bring it against a government hospital or a clinic, I have 3 years, 36 months actually, according to the Private Authorities Protection Act, from the date of the tortious act. But then this all changes once more when the claim is on behalf of the deceased patient, right? So in this regard, there are two kinds of claims that can be brought by the dependents of the deceased for losses incurred by the dependents themselves. This is pursuant to Section 7 of the Civil Law Act, or an estate claim, meaning an administrator or a representative of the estate sues on behalf of the estate and or its beneficiaries. Now, there's a very clear difference between the two. A dependency claim is where a dependent sue for their losses. A dependent meaning, let's say, patient A has 2 children, right? As a result of his demise, which was the result of negligence, these children lost the support or contribution that the parent had provided them, had to pay for his funeral expenses, and also had to suffer bereavement or mourning. So these are losses classified under a dependency claim. But an estate claim is different. An estate claim is where an appointed representative goes to court. And when the court looks at the representative and sees the word estate claim, the court does not see the representative. The court sees the deceased patient as if he or she were alive before the court, claiming for his or her injuries. And that would, for example, include the deceased pain and suffering for however long as a result of the negligence, aggravated damages, etc., so on and so forth. But it is always safer to seek advice, especially on the issue of the limitation, because it is often not a straightforward case. Some cases may involve different hospitals and different doctors. Doctors may practice in more than one hospital. There may be overlaps in limitation periods. Of course, your lawyer will calculate and advise you of the earliest possible expiry, but this would require an evaluation of various facts. So let's talk about the first step, the obtaining of medical records. There are various issues here. One, let's talk about right of access. It is true, it is the law, in fact, that a patient has right of access to his or her medical records. But some patients do have certain misunderstandings about this particular statement. Right of access simply means that if a request is made, a patient should be provided a copy. That being said, it doesn't mean that the access is free. There's some certain administrative charges may be needed, or that it means that they get access to the original records. So the original records are the property of the hospital and can be summoned to the court in very specific circumstances. But more often than not, the copy of the records is usually provided to the patients. That one's no issue. There is also a distinction between records and a report. So medical records are contemporaneous, meaning made at the time of the incident. So such things could include ICU charts, prescription charts, admission notes, nursing notes, doctor's notes, so on and so forth. They are often voluminous depending on the type of cases, and they are often created at the time of the event. But a medical report is different. A report is something created retrospectively after the event. It is a summary by a doctor of the events that happened. Sometimes it could be more elaborate, sometimes it could be simpler. Government hospitals have basic reports, detailed reports, specialist reports. But these hold different weight in terms of evidence than medical records. And it is important to know what you're getting. Now, when a patient requests, sometimes they are given reports. Sometimes they're even given excerpts of records. It is rare for a patient to be given by a hospital the complete set of the records, especially by the private hospitals. The government hospitals have a standing policy to insist on a court order before production of a medical records can be made. So a lawyer will really be required for that regard. Now, let's talk about an inquiry. Now, earlier when we talked about Madam Lim's case, there was an issue of an inquiry done. And it can mean two different things depending on a private hospital or a government hospital. So let's talk about internal inquiry documents, a term more familiar when we are talking about government hospitals. It is usually the practice of government hospitals that following adverse events at a hospital, they will investigate it. They will organize a committee, they'll examine the medical records, they will investigate or they will interview the witnesses involved, including the doctors that were involved, and they would create an internal document that will outline the shortcomings with a view, for many reasons, improving systems. The law is quite clear on this regard. This document is discoverable. That being said, it is at least in my experience that they don't make voluntary disclosure of these documents, and therefore a lawyer would be necessary. An inquiry is also done at private hospitals, but the name is a little different. And in fact, there can be a different mechanism as well. So under the private healthcare statutes, which is only applicable to private hospitals and clinics, there is something called the grievance mechanism, meaning that by statute, a private facility is required within a certain timeline to give an answer to a particular patient's complaint or grievance. So the timeline is basically this. If I am a patient and I suffered adverse treatment, I complained and I raised my complaint with an officer of the hospital, any hospital. It could be someone from their customer service, it could be the doctor himself, etc. By statute, they are supposed to forward that to their patient relations officer within a specified amount of working days. And then from there, that complaint is to be forwarded to the CEO, again with another specified number of days. And then from there, they have, I think, 10 working days to provide the patient with an explanation addressing the grievance, including the results of any investigation undertaken. Whether or not this is as a matter of practice undertaken at private hospitals will depend on the hospital. But these are some documents that patients can look to request for, and patients should also be mindful of when making the request. But if all else fails, a lawyer on behalf of the patient can file an application under Order 24 Rules of Court seeking pre-action discovery. Now, there was a time when patients did not have pre-action discovery. So the only way to get their records was to file the suit and then seek pre-trial discovery. And then only after receiving the records, they can determine whether or not they have a case or not. But sometime in the recent decade, they enacted 7A, which allowed, patients to access their records before the suit is filed to determine whether or not there are merits. Now, of course, pre-action discovery encompasses more than medical records. It's not simply just, in fact, the Order 7A does not make mention of records at all, but it is a common mechanism used insofar as obtaining records are concerned, right? Especially on behalf of patients for medical negligence cases. Now, let's say you've obtained all the records, all the reports. The next step would be to engage an expert. Now, I will be the first to say that not every case requires an expert, but the reason experts are so important in medical negligence cases are because Malaysian law follows the English law, right? In the English law, there are two famous cases called Bolam and Bolito. And to put it in extraordinarily layman's terms, Bolam states that a doctor is not negligent if a professional body of opinion supports the treatment that he provided. So the converse would apply in proving negligence. If there's a body of opinion that does not support his treatment, he can then be found to be negligent. But Bolito is the second qualifier to the Bolam test. Bolito states that the opinion itself must be reasonable, logical, must stand up to analysis. So it is when taking these two together, then we see why experts are needed. Experts. If you wish to sue an orthopedic surgeon, you will need to call or get an orthopedic surgeon to give a report, to give his opinion, and to give evidence on, one, the standard of care. What is the appropriate standard of care applicable to that doctor in that particular patient's case, but in this case, orthopedics. Two, what that standard of care would entail, meaning what ought to have been done in that particular patient's case. And three, whether or not such things were done in this case. And if they were not done, they will be called shortcomings. And finally, the key point, the issue of causation, that such shortcomings, such negligence had caused or materially contributed to the injuries of that patient and the resulting losses. It is not always the case that simply by showing negligence, you have a case. You must be able to connect it to the harm, right? And sometimes it's not a straightforward thing. So you will need an expert to deal with both issues. And sometimes you may need more than one expert. I have certain cases where I've gone to 3 or 4 different liability experts just on liability. Now, many patients do ask me as well, can my treating doctor be my expert? Often the doctors that did the remedial surgery or attended to them and had advised them about their condition, and sometimes in certain instances even told them that they should find a lawyer. I think it's important for patients to understand the difference between experts, especially, and treating doctors. The key difference between the two is their independence. The answer to the hypothetical question is that treating doctors cannot be independent experts. Why? Because they're not independent. They received money and treated this patient personally, and therefore are in no position to give independent opinion regarding the treatment and management of that particular patient's case by the doctor who they took over from. But an expert is different. An expert that is appointed must be able to say, I am a specialist in my field of a number of years. I have never seen this patient. My role, I am able to give independent expert opinion. I am free from conflict whatsoever. And these are my views. And because the expert is independent, the court will give weight to that. Of course, the plaintiff will call an expert, the defense will call an expert, and the court will then evaluate the evidence between the two differing opinions as to see which one he or she is more logical, more reasonable, would stand up to analysis. But it is true that engaging in experts does come at a certain cost. It is not easy. And many patients, when engaging an expert, must consider whether or not their counsel, their appointed counsel, has experienced an expert in the particular field relevant to that particular patient. Because more often than not, I am approached by patients who tell me that they have difficulty accessing lawyers, or even fellow lawyers who have difficulty accessing experts. And there was a judgment years ago by a now retired federal court judge, a long, very well-known federal court case that talked about that acknowledged the difficulties of patients getting experts, or getting experts in medical negligence cases in the first place, because doctors, like lawyers, are such busy people. It's hard to get them to want to go to court, let alone get them to get involved in another doctor's problems, whether to criticize the management or to defend it. But assuming you get the necessary report, then it would be to prepare the claim, right? This is a standard document. One is the writ, and one is the statement of claim. The writ is a simple summons document. Most patients need not concern themselves unduly with this. But the statement of claim is a more detailed document that talks about the facts of the case, the particulars of negligence, the injuries, losses, the special damages, and what is sought after. But I cannot understate the role of a lawyer in all of this, and the importance of seeking legal advice and legal counsel before undertaking all of this. I tell all of my clients that I work in 2 stages. The first stage is exactly what I've told you. I get the records, I engage an expert, I prepare the claim. And this timeline, while it varies from law firm to law firm, can take a year or more, sometimes more. And due to various factors in the case, it could be difficult to find an expert. It could take a long time in the courts to get the records, depending on the level of objections. There could be other issues as well. But I think this is quite an underrated aspect that cannot be overemphasized. That being said, I will now conclude my part of this webinar. I now pass the time to my colleague Jason to talk about what would happen after the filing of a suit and the processes involved. Jason, over to you.
Thank you, Jeremy. So, having understood the considerations before filing a claim, we are now at the stage of discussing what are some of the factors to take into account when filing a medical negligence suit. So, the first document, essentially, the initiate legal proceedings, is something called a writ of summons. A writ of summons is like a notice to the defendant telling him that there is a legal action being started against him by the plaintiff. And once, just now, Jeremy spoke about limitation period. So once a writ of summons is filed in court, the limitation period stops running, the time stops running. And the reason for the service of the writ of the defendant is so that essentially the defendant is made aware of legal suit impending against him. And the writ essentially, if you looked at the box of the Malay wordings at the bottom, this is a sample of what appears on the writ of summons. It essentially commands the defendants to act within 14, and we will talk more about the time period for these pleadings later. But essentially, the writ of summons commands the defendant to act, and there are consequences for not acting after being served with the writ of summons. The second document that usually accompanies the writ of summons is something called a statement of claim. The statement of claim set out the foundation of the claim, essentially because the plaintiff is the one initiating a claim. The plaintiff bears the burden of outlining all the facts that entitles the plaintiff to the remedy that he is seeking to defend. In a statement of claim, the plaintiff will really set out material facts regarding the subject matter of the dispute and also the remedy and relief sought in the statement of claim. And once the writ and statement of claim is served on, the defendant then must file something called a memorandum of appearance. An appearance usually refers to the act of coming to court by a party, either in person or through a solicitor. The purpose of entering appearance is for the defendant to submit himself to the jurisdiction of the court, which normally indicates that the defendant's intention to defend the action. So once the defendant receives the writ, the defendant must then make known the defendant's intention to defend the claim, basically telling court that, hey, I'm aware of the claim, I'm here to defend myself, by filing the memorandum of appearance. After the memorandum of appearance is filed, then the defendant is filed a defense. A defense essentially is the defendant's written answer or reply to the plaintiff's statement of claim. It's a document filed by the defendant disputing the plaintiff's claim and also putting forward the defendant's version of events, the defendant's defense to a claim filed by the plaintiff. And it includes such facts as the defendant wishes to assert at trial position in the plaintiff's claim. Essentially, the defense puts forward the defendant's version of events. One thing to note is that a failure to deny a statement in the statement of claim would tantamount to an admission of fact pleaded in such statement. Hence, it's important in a defense not just to put forward the defendant's version of event, but also to dispute what the plaintiff states in the statement of claim. Alongside with the defense, if there is a need for a counterclaim is brought together with a defense. An independent cause of action is something separate to a defense made in the action by the plaintiff. It's a separate and independent action by the defendant, which the laws allow to be joined to the plaintiff's action in order to avoid multiplicity. So an example of a counterclaim in a medical negligence claim, for example, is when a plaintiff files a claim for medical negligence in court, the hospital or the doctors might file a counterclaim saying that there is an outstanding hospital expenses that has yet to be paid, and they are now claiming for that outstanding hospital expenses. So this is something that can be raised in a counterclaim together with filing. And once the defense is filed, there is an opportunity for the plaintiff to file a reply to defense. And something to note is a reply to defense is not required in all cases. It's only required in cases where there is new facts pleaded that necessitate a reply. And this will normally only arise when there are contents in the defense which raise issues that needs to be answered. Some of the examples of things that needs to be replied to are, for example, where the defense raised a point for the first time which require clarification by the plaintiff, or where there are new matters that have arisen and that has arisen from what is pleaded from the defense. And there is no point essentially to reply to a defense if you are essentially only denying all the. If there is a counterclaim filed, then there is an opportunity to file something called a defense to counterclaim. It acts as a defense in reply to the counterclaim, which acts as a statement of claim. Something is very mouthful, but essentially when there is a counterclaim filed, the defendant is now the plaintiff and the plaintiff is now the defendant in that action. So perhaps this image here will make it clearer for everyone on the stage of preliminary pleadings in the court. As I said just now, the writ and statement of claim is the first documents to be filed in court. The writ has a validity period of 6 months from the date of its issuance. So for example, if the writ is filed on the 2nd of, then the writ is valid for 6 months from the 2nd of February. After that, the writ is no longer valid and the plaintiff would need to make an application in court for a renewal of that writ, right? For statement of claim, if the statement of claim is not served with a writ, it can be done anytime after service of the writ, but it must be done before the expiration of 14 days after the defendants enter an appearance. As for the memorandum of appearance, the memorandum of appearance has to be filed 14 days after service of the defense and counterclaim has to be filed 14 days after the time limit of appearing or after the statement of claim has been served on him, whichever is later. And after receiving the defense and counterclaim, then there is a time period of 14 days after the service of defense to file the reply to defense and also the defense to counterclaim. And essentially, all these documents, the writ of summons, the statement of claim, the defense, counterclaim, reply, all these are collectively referred to as pleadings. Pleadings are where a set of facts are set up as case, either for the plaintiff or for the defense. And the purpose of a pleading is to prevent surprise and to enable disputes to be litigated in an orderly fashion. The pleaded facts avoid the element of surprise, and based on these facts, parties will be able to know the evidence that has to be adduced in support or in rebuttal of those facts. And if a party failed to plead a particular fact, then the party is not allowed to raise the issue subsequent at trial. So at the expiration of 14 days after service of the reply to defense, or at the expiration of 14 days after service of the defense, there is something called a close of pleadings. After the close of pleadings, if parties intend to adduce new facts by way of pleading, they would need permission and leave of court to do so. So after close of pleading, the court would usually set a case management called a pre-trial case management. A pre-trial case management is where the courts come together with parties and to discuss on some of the directions that the court will give to parties moving forward to enable the trial to be smoother. So these are some of the directions that usually the court will give. The first one is reference to mediation. The court will try to encourage parties to mediate the matter in an attempt to reach a settlement before the trial starts. First is reference to mediation. Second is filing of the bundle of pleadings. The bundle of pleadings is a bundle essentially consisting of all the documents that we've mentioned earlier. The statement of claim, the defense, the reply to defense, counterclaim if any. So that's the bundle of pleading. The third direction is usually the filing of common bundle of documents. Common bundle of documents is a bundle of documents consisting of documents by both the plaintiff and the defendant. For the common bundle of documents, the court will usually require the plaintiffs and defendants to agree on classification for the common bundle of documents. Classification of documents can be divided into Part A, Part B, or Part C. Part A is where the authenticity and the content of the document is not disputed. This usually occur in things where there is, for example, an official search, an SSM search of the company. If the report is not disputed, the content is not disputed, the authenticity is not disputed, then party will usually categorize it as a Part A document. Part B documents where the authenticity is not disputed, but the contents are disputed. So this usually the bulk of documents will fall under Part B documents. Part C documents are when both the authenticity and the contents of the document is disputed. This essentially means that the party is alleging that the document is obtained through fraud or that some sort of forgery involved here, and that's why parties are saying that the authenticity is disputed. When a document is marked under Part C, then the court would usually require for the maker of the document to come before the court to testify on the authenticity of that document. And that will usually require whoever that produces the document, whoever that makes the document, to come before court to give their testimony. If the document is marked under Part A and Part B, that requirement is no longer needed because the authenticity of the document is not disputed. So the next document under pre-trial case management is the filing of statement of agreed facts. Usually before trial starts, the court would want party to agree to as much facts as possible to allow that during the trial, the issues are narrowed down so that the trial can proceed smoother and it lessens down the time during trial. So the statement of agreed facts is usually facts that are agreed between both parties in relation to the claim. And the issues to be tried is where the plaintiffs and defendants agree on issues that the parties want the court to ponder upon and to deliberate upon. That's the issues to be tried. So both the statement of agreed facts and issues to be tried has to be agreed upon by both parties before filing in court. Next document is in relation to exchange and filing of the list of witnesses. And alongside with that is directions in relation to filing of witness statements. So the witness statements will be a statement by witnesses that are to be called during the trial. And the court, in line with the witness statement, will also give directions on expert witnesses, when expert reports are to be filed, and etc. So these, in essence, are some of the directions that the court will give during a pre-trial case management. And when we arrive at the next process, the trial takes place when the court is ready to call witnesses giving evidence. Ordinarily, during a trial, the plaintiff will begin its case and the plaintiff will adduce evidence through witnesses. The evidence through witnesses will result in the witnesses being subject to examination in chief, cross-examination, and subsequently re-examination. And after the plaintiff have all evidence through its witnesses and closes its case, then the defense will then adduce witnesses through, again, examination in chief, cross, and re-examination. And the defendant's counsel will then, after it has closed the case, call all its witnesses. The defendant will then make a closing speech, and the plaintiff counsel will reply to that defendant's speech. That, in essence, elaborates what a trial process looks like. A trial process can range anywhere between 2 to 3 days to weeks if there are many witnesses to be called. And subsequent to the trial process, the judge will sit down, sometimes order parties to make further submissions on the matter, ask for clarification, and then the judge will either make a decision on that day itself or set another date for parties to come back where the judge will give his decision on the case. Once a decision is made, then if there is a party unsatisfied with the decision made in the High Court, then there is a timeline for the party to appeal against the High Court decision to the Court of Appeal. And the timeline is 30 days from the decision of the High Court. Appeal is normally started by filing a notice of appeal within 30 days. So this 30 days timeline is crucial if a party wants to file an appeal against a decision of the High Court. And something to note is an appeal to the Court of Appeal is an appeal based on a question of, in essence, that means there is no recalling of witnesses in the Court of Appeal. The Court of Appeal will not call all the witnesses that we have mentioned just now, subject them to examination in chief, cross-examination, re-examination. All this will not happen in the Court of Appeal. The Court of Appeal essentially will rely on the evidence that is produced before the court in the High Court and deliberate on a question of law only. So essentially, this is a very brief run-through through a trial process, essentially from filing the writ and statement of claim up until when the judge makes a decision, and subsequently, if there is an appeal needed, then an appeal is filed in the Court of Appeal. So with that, I end my session now, and I'll pass it back to our moderator, Akil.
Thank you, Jeremy and Jason, for your insights in understanding medical negligence claims, patient guide to medical litigation. We will now move forward with the questions from the participants for the Q&A session. Let me read out the question. The first question would be, will the slides be available after this talk? I'll assist in answering this question. Yes, these slides will be available after our talk, and it will be available at our website. Okay, moving on to the next question. The question reads, should a patient try to obtain his medical records from government hospital first before engaging or getting legal advice? I'll pass the question to Jeremy.
Okay, it's an interesting question. In my entire career handling patient cases, I have not been able to see a patient obtain the records, the full set of the medical records from a government hospital before coming to me. And there's a simple reason for this. Even if I were to write on behalf of a patient to a government hospital, they would write back to me and said, we can only give a report. The medical records you will have to get by way of a court order, following which I will have to then file an application in court, and the Attorney General's chambers will then come to court, and then they'll say, okay, we agree to give this, we don't agree to this, don't agree to that, and then we will record the terms of the consent judgment before the High Court. Now, if a patient is capable of doing all this on their own before seeking legal advice, then either that patient is a lawyer himself or herself, or that patient is just extraordinarily talented. There are many like that, but I've yet to see it. And I would hesitate to advise patients to undertake this process on their own because there will be many things to look out for. When applying for pre-action discovery, there's the civil process of applying for it. There's you will have to keep in mind the civil procedure as well as the documents to be filed. And these are not often straightforward. It would undeniably be better to have some legal advisors, someone who will know how to frame such an application before it is filed. Many of the patients that do contact me simply bring reports if they have it, even sometimes hospital bills or things like that. And from there, I can at least, or my team and I can then at least verify or consider those facts with a view to verifying the elements linked as to what the claim is about. Some cases really don't need records to tell for a lawyer like me to tell a patient you have a case. If you underwent surgery to remove your left adrenal gland and the right one was taken out, that's obvious negligence, right? You would still need the records, ascertain that the wrong one had been taken out and what happened during those events and what was documented by the doctors and the nurses at that time. A report would certainly be useful from the doctor. It would provide an explanation as to why he had taken out the wrong organ, right? So it's not necessarily the case that you would need the records before going to a lawyer. At least in the practice of this one, that we will address the patient with whatever information is available. So I hope that sufficiently addresses the question.
Thank you, Jeremy, for answering the question and sharing your insight on it. I'll move on to the next question. I think Jason can answer this question. The question reads, how much does it cost to engage an expert?
Thank you for the question. It's for engaging an expert, the cost would really depend on the expert that we engage. An expert would usually charge his fees based on first the complexity of the claim, how much time he has spent on looking at the records and preparing his report, and also the volume of documents involved. In a simple case, it can be anywhere between 3 to 5,000 ringgit Malaysia or below. But for more complex cases, some experts may charge anywhere between 10,000 to 15,000 ringgit Malaysia for complex cases involving large volume of documents. And on top of those, the fee for preparing the report, experts will also charge additional fee for attending court subsequently if their attendance is needed during the trial. So it's not a very direct answer in relation to how much cost is involved in relation to engaging an expert, but these are some of the estimations that we can give in relation to engaging an expert.
Thank you, Jason, for answering the question. Another question from the audience is, what is the cost for legal fee for medical negligence claims? I'll pass the question to Jeremy. Thank you.
I truly hate to be able to have to say this because I recognize that it's such a cliche, but it depends. It depends on the lawyer, obviously, as to how they would undertake their practices. There are various practices as to whether or not fixed billing would apply or delayed billing. That's legal fees, and I believe that is the premise of the question. But if I look at what is the cost for the legal fee for medical negligence claim, so that's on the lawyer side. But certainly, patients can claim as part of their suit party and party costs. Right? It's one of the items of damages. The basic idea is that you will tell the court, or your lawyer will tell the court, as a result of the negligence, which the court satisfied that there is, I have been made to incur legal costs and therefore I seek a sum for this. And in fact, in recent times, the courts have not only recognized this claim, but have given increasing sums, anywhere between 150 to 250,000, depending on the case and its complexity. And that's the main reason is because of its complexity, that medical negligence claims are complex in nature, requiring a great deal of undertaking. So this is something that I personally account for when it comes to working on my client or working on my own clients' cases. But it's often not a straightforward exercise as well. There are many principles to be considered. Costs and out-of-pocket expenses, meaning expenses incurred as a result of the case, are often distinct and claimed separately, but under the item of party and party costs.
Thank you, Jeremy. We can take one more question. The question reads, what kind of expert would you need to get if you want to sue against an A&E doctor? Jason, will you be able to assist for this question?
Sure. So essentially, if you want to bring an action against an accident and emergency doctor, you would need an accident and emergency doctor to give evidence in relation to the standard of care and to determine whether there is negligence in that accident and emergency environment. However, it may not be the only expert that you need. One example that we can give is if a patient in an accident and emergency department suffers for example, an undiagnosed brain bleed, and the patient subsequently collapsed at the A&E department, underwent brain surgery, and subsequently was rendered in a vegetative state. In such a situation, an additional neurosurgical opinion might be needed to establish something, a legal term that we use called causation. Essentially, that means that if the brain is to determine that if the brain bleed had been diagnosed earlier, whether the patient's vegetative state could have been avoided. But as with every medical negligence claim, every case would really be very peculiar on its own facts. And engaging an expert is not a straightforward exercise. It requires us to look through the records to determine whether there are various specialties involved and what kind of experts that we need to engage at that juncture. Thank you.
Thank you, Jason, for the answer. I think there's one last question for you. The question is, can I get compensation for medical negligence without a suit? What if I contact the hospital and doctor and try to...
Okay, I'll make this short. You're welcome to try, but there's a reason why there are claims in the courts. Certainly not for fun. It takes time. One thing you keep in mind, most private institutions, private hospitals and doctors, they are privately insured. And so the power to settle is not really in the doctors or the hospital's hands. Even suing a government hospital involves the government of Malaysia. There's no harm in trying, but in my experience, the chances of success are less than 30%. Better to get a suit, show your cards, and then bring them to the settlement table.
Thank you, speaker.
Let me allow to take this one last question that I happened to notice in the chat. What are the prospects of a medical law expert who is a doctor working in your company? Is there a career pathway? Not particularly related to this subject, but sure, this is something you can reach out to my firm for if you wish. You can send an email to my firm or to myself. You can find the details on my website, on our firm's website. But there are many who practice in this field that engage medical advisors for their work, though the needs of a particular lawyer practicing in this field would be very different. But I welcome a conversation in this regard.
I think that's all for today. Thank you, speakers, for your insight and sharing your knowledge on this topic. Before we conclude, I have a few announcements to make. Firstly, please join us again for our upcoming talks. There's one talk on 28th May 2025 on understanding dismissal and remedies under Malaysian Industrial Relations Act 1967, and another one on 11th June 2025 on common property disputes, recovering or defending ownership. Secondly, please fill out our feedback form and tell us what are your thoughts on our talk today, and the link to the form will be posted in the chat. And please follow us on our social media accounts. We are available on YouTube, Twitter, Instagram, LinkedIn, and also Facebook. Fourthly, if you would like to speak with our lawyers, we offer a complimentary consultation up to 30 minutes over the phone or via video conference. So please fill in the form on our website. The link will also be posted in the chat box. And last but not least, to our guests, thank you for joining us today. We hope you found our today's session informative and useful. Thank you, everybody, and see you at our next talk.